Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
And our guest today is Chris Maiorana, who's a patent lawyer out of Detroit, Michigan, St. Clair Shores, just north of downtown. Chris, how you doing today?
Good.
Good. Hey, tell me a little bit about yourself and your firm.
Okay. Well, I'm a patent attorney. I have two other attorneys that work with me. So we're a small intellectual property law firm. We tend to call them a boutique when we specialize in intellectual property only.
And what is intellectual property law?
Intellectual property law is a general umbrella term that the judges came up with maybe 20 or 30 years ago that covers patents, trademarks, and copyrights generally.
And patent law, is that the same thing then?
Yeah, patent law is a subset of intellectual property law.
Okay. And so can you give me the definition of patent law?
So a patent is a right to exclude someone from using your invention. So you only get a patent if you are successful in what we call prosecuting the patent through the patent office. So you apply for what you think is your invention, then you have to negotiate with the patent office to get your invention to ultimately issue as a patent. So a big part of what we do is work with the patent office to get our inventors' inventions pushed through. So we look at the patent office as a big red tape machine, and we cut through the red tape for them.
Okay, I see. And I think I saw this on your website, but you've issued over 1,600 patents. I mean, that sounds like a lot. How does that compare to other law firms?
Yeah, that's something we take a lot of pride in for sure. So we've had 3 core attorneys for over 15 years now, and to get up to that number of patents, we get roughly 30 to 40 patents to issue per attorney per year. And there's some surveys that come out once in a while that show all the different law firms that respond, like how many patents they have per attorney. So our numbers are usually put us at the top of the list on a per attorney basis. So, and part of that is because we specialize in, patent law particularly. So that this is our number one aim, is to get a lot of patents allowed for our clients.
Now, I suppose that your average customer is looking to get the best deal that they can. They want your help, but they don't want to spend a ton of money. Is there anything you do to keep your costs down, or how does that work?
Sure. So there's, in general, 2 types of clients that we work with. There's corporate clients that have multiple inventions per year. So we work with them over and over. And then there's sometimes smaller clients that just have just one invention that's their big idea that they need to push through. But either case, the issue is each time the patent office mails what we call an office action, we need to respond to that. And there's attorney fees involved in that. So if we can limit our interaction with the patent office to one main response and then get a patent for somebody, that's super effective, because then they don't have any follow-up legal bills. So that's our goal, is to only have to respond one time. And if you look at the stats on that, we're about 15 to 20% above average of what everyone else does. So there's stats at the patent office that say how many cases are allowed with only one response. So that's the best way to really cut down the bills. And even if you have to do a second response, we still do less responses on average than your average patent attorney, and that leads to a significant savings. And if you're a big client that has a portfolio, and you're doing 2 or 3 responses a month, maybe even more, if you can cut down the total number per case, that's good. But if you're paying the bill out of pocket and you have your big idea, you'd still rather only have one bill than 2 or 3.
Oh yeah, absolutely. Is there a certain technology you specialize in?
Yes. Most of our clients, believe it or not, are out of Silicon Valley. So we do high-tech chip patents. And that's because we had some ties with some good guys a long time ago that just continue to give us referrals on that. And similar to the idea that I mentioned about saving costs, that they recognize that, we do have more of a Midwestern overhead compared to a West Coast overhead, so they can save a little bit of money there. And then the idea that we do less responses with the patent office, they've generally been pretty happy and have referred our names out to other people. So the high-tech electrical chip patents are our number one specialty.
Do you work with other technologies?
Yeah, sure. We can do other things, and easier mechanical things, we can handle that. I'd say the only thing we really don't dabble in, that's a separate subspecialty, is chemical patents. We don't do things like that.
Okay.
Electrical and mechanical, we can do most of that, sure.
Yeah, go with what you know. Absolutely, go with
Right.
what you're an expert at. How does a person find out if their invention is already out there?
That's always a trick for sure. The general idea is we do a patent search, and we can either do that for a fee for a client, or the client can try their own patent search. And that is just normally, modernly a word-based search on the internet. There's different databases that we'll use, and there's tricks that we can do to really dial into these things a little bit quicker than the average Joe can find them. But usually, whether it's a small client or a big client, we'd like to find something that's close. So if we don't find something that's at least close to an invention, we probably didn't look in the right spot, because there's just a lot of stuff out there. It's amazing how many things are either in the patent database or just on a general Google search.
Oh yeah, I can imagine. Especially right now. How long does it take to get a patent?
It's a sliding scale, like anything else with the patent office. They do say that it shouldn't take more than 3 years from the time you file. So it seems like a long time, but by the time everything gets rolling through the patent office, it doesn't seem to be that long. But they have this system where they have an adjustment to the length of the patent term. So we call it PTA, a patent term adjustment. And you actually get extra time added to the end of your patent if the patent office is slow on certain deadlines. One of their first deadlines is to have their first response to you in 14 months after you file. Then there's other deadlines after that. So if they're slower than that, they will actually add time to your patent. Sometimes that adds up to years extra time.
So that brings me to my next question. How long does a patent last?
Yeah, that's a good question. So they changed this rule a few years ago. It used to be 17 years from when your patent issued, and they changed it to 20 years from when your patent is filed. So that's where that 3 years that they're trying to meet comes in. So if you file and they get your patent to issue within 3 years, then you actually have more time than under the old system. And that was part of the negotiation when they changed the law. They didn't want to shorten patent terms, so you should only get more time under the new system than the old system, at least as much, never less.
Right. Okay, so how do you enforce the patent? Let's say some guy steals my idea. What do you do?
Yeah, there's a whole other subspecialty of litigators in patent law that will file a lawsuit on your behalf and try to collect royalties from a potential infringer. But that's lawsuits are expensive, and that's a tough business. So that's a lot of the acts of Congress are based on whether there's too many or too few patent lawsuits out there. In general, they think there's too many, but general terms don't always cover everything. So very, very complicated stuff when you get into litigation like that. Ideally, you would work something out with a potential infringer before you had to file a lawsuit.
Yeah.
And
yeah, absolutely.
so it seems like both parties would be open to that, but in reality, anyone who gets a letter from someone else about a potential infringement always says the other side has a bogus patent that they're trying to shake me down on. So
yeah. Do you get involved in that kind of litigation?
Sometimes, not really a lot. We're more of the dealing with the patent office specialists. So the breakdown is the attorneys that deal with the patent office, we usually call them prosecutors, and the attorneys that deal with lawsuits are the litigators.
Okay.
And prosecutor sounds like you think of a criminal prosecution, but for whatever reason, that's what we use to talk about dealing with files at the patent office. It's called patent prosecution.
Okay, I saw a glossary of terms under the heading of patent law when I was doing some research, and three terms that kind of stuck out to me that I was told were under patent law were copyright, trademark, and trade secret. Is that part of it? And if so, what are they?
Right. So the three main issues are patents, trademarks, and copyrights. Trade secrets are another little twist in there. So a patent is for an invention, a trademark is for a name, and a copyright is for a written work. So if you invent, say, a new fishing lure, you'd want to get a patent on that. If you called the fishing lure some kind of fancy named fishing lure, then that would be your trademark aspect of it. And your copyright would be like your graphics on maybe the cover, or more likely like a book or a movie or audio recording.
Okay. I'm going to answer part of this question before. Well, I'll ask it. What should we look for in an intellectual property attorney? And you talked a little bit about that. The ways you keep your costs down, the stuff that you specialize in and that you're really good in. You kind of already talked about that. But is there anything else we should look for in an intellectual property attorney?
Yeah, I would think the number of years of experience would be somewhat important.
Yeah.
You don't want someone that's brand new, but they do say that it takes, like a brand new associate attorney out of law school, it takes them 2 years to learn how to be an even serviceable patent attorney. That's how long the training is. So they should be working under another partner for those couple of years. After that, it's a sliding scale between 2 and probably 4 years, whether they get to be really good at it. So once you get to like your 5-year time frame, that's pretty much where you've become a real functioning patent attorney. So anyone less than 5 years, I'd be a little bit suspect of. And that is a sliding scale. Different people learn at different rates, but that's been the generally accepted time frame, that you need 2 years just to really understand what's going on and 5 years to get really good at it. Okay.
Yeah, that makes sense to me. Our guest today is Chris Maiorana with Maiorana PC. It's his law firm's got 3 patent lawyers there. Hey, Chris, how do we reach you guys?
So if you want to send us an email through the website, it's just maiorana.pc.com. So it's MAIORANAPC.com. or you could call us at 586-498-0670.
Hey, good stuff, Chris. Thanks for being on the program today.
Oh, you bet. Thanks.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.